Well, back in the good old days when I started practicing as a lawyer in the 80s, the person that prepared the will, the lawyer prepared the will, had no obligation to the beneficiaries of the will. Therefore, if mistakes were made, it was extremely difficult for the beneficiary to have a go at the lawyer. Thankfully, the laws have changed and a duty of care is now owed to the beneficiaries, thanks to English law actually, followed by Australian law. Subsequent to that, accountants and advisors and other professional people became obligated to let clients know that they should have a valid enforceable will properly prepared that is tax effective. And that very much came to the front in capital gains tax was introduced in 1985. Paul Keating said, don't worry, there'll be no capital gains tax in your family home, no capital gains tax at death, and yet we know that there is potential capital gains tax on both your family home and the time you die. So what happened? What did the Supreme Court of Tasmania actually say? Well, they made a decision that although there is no precedent at law for it, there's an obligation on this particular lawyer that prepared the will to ask about family members of the will maker. That was not done apparently, according to the Supreme Court. This will maker, this deceased, left everything to a friend and nothing to his daughter. His daughter successfully went to the court and asked the court to rewrite the will, which is so easy to do. And quite often costs are paid from the estate. The main beneficiary of the will, the friend, decided that he would have a go at the lawyer. The lawyer should have done something to help this situation. And the Supreme Court agreed. The Supreme Court said more due diligence should have been done by the lawyer to ascertain, in this circumstances where everything's being left to a friend, whether the testator, the will maker, had family members, a wife, children. In this case, he had a daughter, and the daughter got nothing. So what do we learn from this? We now know the courts are out there gunning for lawyers and potentially accountants and advisors about the obligations that you have when you make a will. In my 30-odd years of practice, I've always made it the correct thing to do is to only do estate planning when you've got the team around with you. That team's the accountant, the advisor, the lawyer, and the tax lawyer, like myself. That way you get holistic needs of the client and fewer mistakes are made. So I implore everyone, get together, bandy round your clients and help them produce their estate planning documents. Enjoy.